Good afternoon, everyone. The current Indian criminal procedure was based on the Code of Criminal Procedure 1898, which heavily influenced the Code of Criminal Procedure 1970. The Bharatiya Nagarik Suraksha Sanhita 2023 has taken effect on July 1st, 2024 and replaced the existing Criminal Procedure Code. The Bharatiya Nagarik Suraksha Sanhita aims to create a more efficient justice system that addresses challenges such as complex procedures, case backlog, low conviction rates, limited technology use, and delayed justice delivery. Its primary goal is to protect citizens from exploitation stemming from existing procedural loopholes. While the Bharatiya Nagarik Suraksha Sanhita retains many provisions from the earlier criminal procedure codes, it seeks to simplify the criminal process, shorten trial durations, enhance police investigatory powers, and establish procedural timelines. The Bharatiya Nagarik Suraksha Sanhita is not an arbitrary measure. It is based on empirical research with a clear objective to safeguard the right of citizens during criminal proceedings without undermining the rights of victims or accused individuals. Additionally, the Bharatiya Nagarik Suraksha Sanhita includes initiatives like sentencing guidelines to prevent arbitrary sentencing and aims to balance the rights of all parties involved in the legal process. To grasp the various nuances and intricacies of the Bharatiya Nagarik Suraksha Sanhita and to explore its legal framework in greater depth, we have with us Professor Chirag Walyan, Assistant Professor of Law, Maharashtra National Law University. It is my proud privilege to read his brief profile in front of all our learned members. He is postgraduate in law and also has completed 2 years master degree in mediation and conflict resolution. He heads the Arbitration Center at Maharashtra National Law University and is an editor in chief at Indian Review of International Arbitration. He has received Best Arbitration Academic Award from Indian National Bar Association and Outstanding ADR Educator Award from Asia Pacific Center for Arbitration and Mediation. It is our proud privilege to have him as a speaker for today's session and get benefited from his words of wisdom in the interesting yet technical area of Bharatiya Nagarik Suraksha. Now we welcome him at the 24th session of Triple E 4.0 Master Knowledge Series and hope to have enthusiastic learning. All the participants are requested to post their queries in the link provided for posting the query. Sir, you are welcome. You may please start the session.
Thank you, sir, for the kind introduction. The introduction given by sir is from my arbitration profile, the component for which I usually take classes for the PMQ. But I've been teaching criminal law since much later than the arbitration. I was instrumental in setting up Criminal Justice Center at the university, and very recently we submitted a report on commercial sexual exploitation in Maharashtra, which is a study on public prosecutor, and it was submitted to the Ministry of Women and Child Development, Government of Maharashtra. Apart from that, I'll just formally share my two good books are coming on criminal law. They are based on the theme of criminalization, which are published by Brill, and my earlier work on criminal law was published by Thomson Reuters, Revisiting Reforms in the Criminal Justice System. So way back in 2020, when the book Revisiting Reforms came, at that time, government hadn't set up the committee, which it did set up before enacting the three new criminal laws. So it was at that particular point of time, we were thinking that if some changes are to be introduced within criminal law, within criminal justice system, what those changes should be. And I'm happy to share that many of the recommendations, proposals, which we discussed in that book published by Thomson Reuters in 2020, we could see many of them getting reflected in Bharatiya Nagarik Suraksha Sanhita. This is just a formal part of it. Let's come to the subject matter. Sir mentioned in his introduction that our criminal procedure law, which is replaced by BNSS, is a colonial relic. I do not agree with that statement because he mentioned about two laws, 1898 law and 1973 law. 1898 law was prepared by our colonial masters, but 1973 law was made in 1973 pursuant to 41st report of the Law Commission of India, which was submitted in 1969. So it was made in independent India. So BNSS has replaced a law which was made in independent India by us. What is still colonial, what was colonial about 1973 law and what is still colonial about BNSS, if you read many commentaries about the law, is the institution of police, is the way our court functions. And with respect to that, we don't see much change. Now, why I say that institution of police hasn't changed? I want to draw your attention to why in a country we have a procedural law, procedural criminal law. Its purpose is very different from civil procedure law. All of you being the citizens of this country, and I'm not telling you this because you have something to do with law, this might help you in practice, but this is something we should know as the citizen of our country. We have Article 21 of the Constitution, which says every person has a right to life and personal liberty, except according to procedure established by law. Means we all have life, we all have personal liberty, and this life and personal liberty can be taken away by procedure. This procedure is criminal procedure. This procedure is, in the language of 2023, 2024, is Bharatiya Nagarik Suraksha Sanhita. So what the Constitution guarantees you, life and personal liberty, are taken away through the procedure laid down in these laws. And that's why examination of these laws are very critical and crucial. And every person, every citizen must know about these laws, about these provisions, because they deal with something which we have our confrontation on day-to-day basis. Something like arrest, something like first information report, something like trial, which is happening. We see these happening in and around our neighborhood, also at a larger level in our society, with what happened with many of the politicians when some investigation or high profile cases, when some investigations, inquiries and trials are going on. So this code of criminal procedure deal with these aspects. Bharatiya Nagarik Suraksha Sanhita deal with these aspects. Having said that, if the Constitution guarantees life and personal liberty in criminal procedure, Bharatiya Nagarik Suraksha Sanhita takes it away, then who must be the most important stakeholders of this legislation? The most important stakeholder of this legislation should be then the people who are arrested and people who are accused. We can call them, label them as criminal. Though criminal is a word with negative connotation, law does not use the word criminal. Law does not say anyone as a criminal. Law has its own vocabulary. Even in the criminal procedure code, criminal does not mean a person. It meant a body of law. Okay. In order to denote people who are covered under these laws, we use the words like arrested, accused, convicted. These are the three words. With respect to children, we use the word juvenile or we use the word child in conflict with law. We do not call a person as a criminal. Criminal in any society which is based on rule of law which is based on democratic principles, which is a civilized body, we do not use such terms which are against the values of human dignity. So the ultimate purpose of any such law is to safeguard dignity of the individual, personal liberty of individual, and life of individual. So obviously the most important stakeholders are people who are accused or arrested. When the name of the law is changed from Criminal Procedure Code to Bharatiya Nagarik Suraksha Sanhita, we are changing the discourse. We are changing the focus of the law. We are saying that the focus is not just people who are arrested or accused, but stakeholders in a criminal justice system are also victims. Society, Nagarik Suraksha, society, citizens. Nagarik means citizens. Citizens are also important stakeholders in a criminal justice system. So the philosophical discourse of the law is changed. Now, life and liberty of citizens and society is not taken away by the criminal procedure. It is taken of the accused and arrested person, and therefore, rightfully, this law provides that various authorities established under this law, such as police, prosecutors, courts, prisons, they shall not abuse their powers under this law. So the idea is to check the discretion. The idea is to make sure whatever discretion is given to these functionaries under criminal justice system, it is not exceeded and it is in a fixed sphere. It is checked and limited. So this is the purpose of the law. So when you look at the law and judge whether it is a colonial law or not, whether it is a modern law or not, it's not from the perspective of in which year it is passed. It is from the perspective of what are the institutions, what these institutions do in order to preserve rule of law, how these institutions ability to arrest people and in an indiscriminate manner is checked by that law, how that institution facilitate easy access to justice. So these are the hallmarks of the modern law. I would submit that many of these things are incorporated in Bharatiya Nagarik Suraksha Sanhita. There are few more things which could be improved, and that's the case with any law. So now, with this short introduction, I will start my formal presentation. This is the law we are talking about, law passed in 2023. This law came into force on 1st July 2024. I have already mentioned difference between Nagarik Suraksha on one side and criminal procedure on the other side. And I'm saying Nagarik Suraksha emphasizes more number of stakeholders in a criminal justice system as compared to criminal procedure. Criminal procedure is a connotation specific to people who are accused of crime, who are arrested of crime. But Nagarik Suraksha shifts the emphasis of this crime, of this body of law to the larger societal interest, which is in some sense problematic, but in some sense it is also good. And I would like to believe it is good because of the declared intent of the government. If you have heard a Prime Minister Modi ji's speeches and the line which the government follows, they are working with respect to commercial sector with a theme of ease of doing business. And in the sectors like this, which touches upon the life of individual, liberty of individual, the theme is ease of living. So ease of doing business, ease of living. And to my mind, their intent is that how through criminal procedure code, we enhance the ease of living. But as I mentioned, there are negative aspects or negative ways of interpreting it also. I could say that this law only concerns citizens, and thereby this law creates a boundary between citizens versus non-citizens. Usually, when a person is declared, and this I'm talking from a very jurisprudential perspective, when a person is declared as a criminal, as an offender, as an accused, we do not consider that person as a part of the citizen. We take away right to vote of that person. A convicted person cannot vote. A person in prison cannot vote. So we take away all the rights of citizen from that person. So the idea could also be, I could also interpret this law to be exclusionary as a law to marginalize certain people, but I would not like to believe so because the time will test the law. I would like to believe that this is a law which is initiated by the government, introduced by the government to facilitate ease of living, to facilitate access to justice. And we will analyze how the use of technology, enhanced forensic science is a step toward modernization of the criminal justice system rather than taking one step forward and two steps backward. I would like to believe that it is many steps forward. So the law is broadly divided into 39 chapters and 531 sections, and there are two schedules. Schedule 1 is about which offense is cognizable, which offense is bailable, etc., and which court shall try the case when the case is cognizable and bailable. And the second schedule is format of various summons, warrants, bail bond, property attachment. So there are many formats which are used in criminal practice. Those formats are mentioned in second schedule. Let's move forward. This law deleted some provisions, but two important provisions which are deleted are, now there's no concept of metropolitan magistrate or metropolitan area. CRPC had this concept that wherein there is a population more than 1 million, the area will be designated as a metropolitan area, and in that area, the concerned magistrate will be called as a metropolitan magistrate. Now, we don't have this concept anymore. We are saying whatever be the population, we are going to have same set of magistrate. So the existing hierarchy is judicial magistrate second class, judicial magistrate first class, chief judicial magistrate as far as magistrate, and the entire concept of metropolitan magistrate has been taken away. Similarly, in the session court hierarchy, the post of assistant session judge has been removed. So we used to have a hierarchy like this in the session court. At the bottom is assistant session judge, then additional session judge, and the session judge. Now we don't have assistant session judge. There are only additional session judges and session judges which are going to hear and try the cases. So all the matters in which assistant session judge had the jurisdiction, they have either fallen to the scope of chief judicial magistrate or they have gone to the session judge. Now, FIR is the most important step in a criminal justice system. So it sets criminal law into motion. And there are three important changes which have been introduced with respect to FIR. First is now FIR can be registered via electronic communication. And if it is registered via electronic communication, the person concerned will go to the police station and will sign it within 3 days, and after which it will become a proper FIR. Now, there are goods and bads of this provision. Good is at the comfort of your home, you could register the FIR. Bad is on two counts. One is the law does not distinguish between two kinds of EFIR. One is EFIR when you go to the government portal and file the EFIR. If I'm going to the government portal and filing the EFIR, like we file income tax, like we file GST returns and many things, we can use digital signature, right? And there's an authentication. There are authentications also in the form of Aadhaar, OTP, Aadhaar verification, etc. Why do you need person to go to the police station and sign within 3 days? This is problematic, especially for those people who are living out of station or who might have been abroad, but with respect to their property or with respect to something they are concerned about, an offense has committed within the local territory of India. So first important distinction is this law does not distinguish, EFIR does not distinguish between FIRs which are registered on government portal vis-a-vis FIR which now can be made by WhatsApp, by SMS, by any electronic communication. So it should be easy filing FIR. There is no doubt about that. The interaction of citizen and police could be reduced, and whatever harassment our citizens face in a police station could be avoided by EFIR. But so much access that if I'm angry with anyone, I just send a message to the police officer and that is counted as an EFIR. So for that particular purpose, yes, it makes sense that you go to the police station and sign within 3 days. But otherwise, if you are doing it on the government portal, this should not be required. So these are my 2 cents on EFIR. Second is preliminary inquiry. Now, prior to BNSS, CRPC, section number 154 dealt with FIR. Section came to be interpreted by a landmark judgment of Supreme Court of India. It is a constitution bench of Supreme Court of India. It is called as Lalita Kumari versus State of Uttar Pradesh. In that judgment, the question before the Supreme Court was whether police should mandatorily register the FIR when an informant comes to the police station, or should police be required to do a preliminary inquiry first to make sure that the allegations in the FIR are true. The court came to the conclusion that registration of FIR should be mandatory because it is just an information. Now, after the information has been received, police officer has all the right to do the investigation and find out whether the case is a genuine or not. So police said registration of FIR is mandatory. Second important reason why the Supreme Court said it is mandatory is it obviously interpreted many provisions. But apart from that, the factor was that if police is given discretion when to register FIR and when not to register FIR, that discretion could be abused and citizens of the country can be harassed. So Supreme Court said a very big no to preliminary inquiry, except from few offences. So it said you can have preliminary inquiry if there is an excessive delay in filing FIR. Point number 1. Then it said you can have preliminary inquiry in medical negligence cases. Likewise, it mentioned you can also do preliminary inquiry in cases wherein offense is committed by a public servant. So in these cases, very loose exceptions were created. Very few exceptions were created, not loose. But now they have introduced a concept of preliminary inquiry, which was generally done away by the Supreme Court. They are saying before FIR, if the offense is punishable between 3 to 7 years. So more than 7-year preliminary inquiry is not required. But if offense is punishable between 3 to 7 years, then preliminary inquiry must be conducted. But then again, there is a gap in the law. The gap is what happened when the offense is punishable with less than 3 years. By objective, अगर आपका ये है that in the most serious offenses there should not be preliminary inquiry, understandable. But what happened to the offenses punishable with 0 to 2 any punishment less than 3 years? That's not clear. But then they say inquiry must be completed in a time-bound manner and within 14 days of receiving the information. So that's about preliminary inquiry. Third important concept is zero FIR. The concept of zero FIR was not written in CRPC, but it was very well in the practice. And there were many judgments of the Supreme Court of India that zero FIR should be registered. Zero FIR means what? Every FIR must be registered in the territorial jurisdiction of the police station where the offense has been committed. So if I am sitting in the Powai area of Mumbai, then the police station which has the jurisdiction over Powai must lodge the FIR. Only in that police station you can lodge the FIR. Now, this is the funny thing, okay, with respect to the area I'm living, and most of you can relate to this. My area is Powai, but the Powai police station does not have jurisdiction over my area. What will I do if some offense is committed? I will search where is Powai police station and I'll go there. And they will tell me, go to Parkside police station. Parkside police station had the jurisdiction over it. So citizens of the country didn't have any mean to identify which police station has a jurisdiction over the place where the offense has been committed. And this usually used to be a cause of harassment to the citizens. So Supreme Court introduced the guideline that if a person has come to you for the purpose of FIR, you just record it. And now as a police station, it is your job to transmit this FIR to the police station with the relevant jurisdiction, right? I'll tell you one example. When I myself was doing law, somebody stole my wallet. I went to the nearest police station. Nearest police station said, we do not have the jurisdiction. They asked me to go to other police station. Now, the problem with me was my wallet has gone. I don't have any document. I don't have any money. How do I even travel from one police station to the other police station? And this has also happened very recently with me when my credit card got lost. And I again went to the nearest police station and I asked them, register my zero FIR. And police officer told me, no, we can't register zero FIR because neither you are a woman nor you are an old person. Why can't you go to that police station? I understand their concern, but this is not what the law told. Law does not say that zero FIR is only for people who are unable to travel to the other police station. Zero FIR means no inconvenience should be caused to any person. But that's not how the police works in practice. Moreover, on a practical side, if we think from the perspective of police officer, say, take an example. A popular area in Delhi is India Gate and Mumbai is Gateway of India. Nearby these areas, a lot of tourists come. And if there are tourists, some offenses could be committed like stealing, theft, etc. So if theft is committed in that area, I can't go back to my home and register FIR. I must go to the police station where theft has committed. Now, if in these kind of tourist areas, large number of offenses are happening, large number of property related offenses are happening, whether that police station has the bandwidth, resources to handle so many zero FIRs. How these zero FIRs are going to be transmitted? Are you going to have a separate person who is going to take a file to the different police station? Are you going to transmit them electronically? If a person has to go, then how does the person who is the complainant gets to know that whether my zero FIR has been lodged at the proper police station? How these expenses are going to be met? So if I'm going, police officer is going from one police station to the other police station so that zero FIR can be converted into regular FIR, then there should be some budget in the police. Whether police has prepared such kind of budget, how the constable who is going to transmit this FIR is going to be compensated. Do they have enough number of vehicles? Do they have enough number of people? So it could become a logistical issue also for the police officer, and we should think about all these things. Some states have introduced standard operating procedures as to how EFIR should be done, how preliminary inquiry should be done, and how mandatory FIR, zero FIR should be done. But those SOPs are also not adequate. I have gone through almost all the state standard operating procedures, but they do not address the doubts I'm raising with respect to these provisions. Then we move to next concept, attachment and forfeiture of property. Section 107 of the BNSS talks about attachment of proceeds of crime. And magistrate has the power to attach the property which is identified as the proceed of crime. And in such cases, IO, which is investigating officer, will have to make an application. And herein, magistrate can pass three kind of orders. He could order direct attachment of property after hearing all concerned parties, point number one. He could order ex parte interim attachment, or third, if notice ex parte interim attachment, that is, if notice to the owner would defeat the purpose of the attachment or seizure, then without hearing to the owner, decision could be given. And third, direct rateable distribution of attached property to victim after determining it as proceed of crime. So a determination is to be made by the magistrate before there could be a rateable distribution amongst victims. It should be determined. It means a judicial application of mind should happen. Some kind of judicial inquiry should happen whether the property is actually a proceed of crime or not. This is mentioned under 107. This is a new provision. Section 86 talks about, this is again a new provision wherein an international assistance is sought for the proclaimed offender, and on a written request by either superintendent or commissioner, court could seek assistance from a foreign court or authority. And the purpose is to make sure that fugitives could be brought back to India, or their properties which are abroad could be confiscated. This is what is the perspective. You all know what fugitives we are talking about here, and the challenges which the Indian government has faced in bringing these fugitives back to the country so that they could be tried in our country. Now, third important feature of the Bharatiya Nagarik Suraksha Sanhita is that, as I mentioned earlier in my introduction, it streamlines many things. It is based on modern things. So it has introduced certain mandatory timelines. Because one of the biggest challenge which people in our country face with respect to criminal justice system, everybody complains that it's very slow, it's lethargic, it takes a lot of time, and that is why your BNSS has introduced many timelines. So for the purpose of committal within 90 days from taking cognizance, and maybe extended to 180 days. What does committal mean? Committal in very simple term means that session court cannot take direct cognizance. And there
Hello. Please see to it. I'll just talk.
excuse me, I lost my internet for a second. Let me resume.
No problem.
So I was explaining you the concept of committal, and committal means transferring of a case by the magistrate to the session court, because session court cannot directly take cognizance. So this is called the concept of committal. So we are saying murder case, the cognizance will be first taken by the magistrate. And then the magistrate, after he has taken the cognizance, he will commit the case to the session. So this committal, earlier there was no timeline in how much time the case should be transferred from magistrate to the session court. Now they have mentioned 3 months, which is 90 days and maximum 180 days. Second is supply of police report and document. Within 14 days from the date of production or appearance of the accused. Now, it is a very important right of the accused because accused has a right to defend himself. And if accused must defend himself, he should know what is the case of police against him. So he should get access to the copy of charge sheet. He should get access to the statements made by the witnesses. He should get access to whatever evidences are collected by the police. So all of that are part of the police report. Now they are saying when the accused is produced before the magistrate or he appears before the magistrate after the charge sheet has been filed, within 14 days, he must be compulsorily provided all these documents. Third, framing of charges, which is formal allegations against the accused by the court. That's what charge is called. And charges must be framed within 60 days. The court must give the judgment within 30 days from the completion of argument. And trial, they haven't put the maximum number, but it should be conducted on a day-to-day basis with a maximum of 2 adjournments. So these are very, what you could say, ambitious timeline, especially pertaining to trial, because usually trial, 1 month is, next date is after 1 month, 40 days. There are very rare cases where the trial is conducted on day-to-day basis because we have very less number of judges. So stricter timelines cannot resolve the problem of less number of human resources we have in our country, we have in our court. That can only be rectified by that. And that's why I say it's an ambitious timeline. Only the time will see. Earlier also we had this provision that the trial must be conducted preferably on day-to-day basis and there shall not be any adjournments. Now they are saying maximum you can have 2 adjournments, but you can't really put a control on it in practice. Now, with respect to arrest also, some provisions have been inserted, amended, etc. There are these guidelines which were given by the Supreme Court of India in the context of CRPC. And the guidelines were in the judgment of D.K. Basu versus State of West Bengal, Joginder Kumar versus State of UP. And the guidelines which flowed from this judgment was that arrested person has certain rights. And out of all those rights, the most valuable right is that when a person is arrested, his friends or relatives must be informed. See, there is a family member of yours and he has been taken by the police station. How do you know that the person is at the police station if the person has just simply been detained? So there should be some way of finding out that the person has been detained. So there was no way of finding out. So Supreme Court said, no, we need to do something about it. And CRPC included certain amendments in that. And as per amendment introduced by the CRPC, I think amendment came in 2005, that friends or relatives need to be informed. Now they have expanded the definition and they are saying, ठीक है, बहुत लोग होते हैं who do not have friends, who do not have relatives, then who is informed? They are saying inform to any person who might be interested in that person. So any person who takes interest in your welfare, could be anyone, you can inform that person and that would comply with the provision of this section. Similarly, on the similar point, they have mentioned earlier in the CRPC, there was a provision that every district must set up a district control room. And in that district control room, people who have been arrested, their details should be flashed. So that obviously their family members are not worried where our relative, friend, son, daughter has gone, whether they are actually in the police custody or not. There was no way of finding out. So if you have arrested a person, you need to flash it in the police headquarters. There has to be a police control room. Now the problem was there were so many police stations. You have mentioned police control room, information need to be flashed. But whether a police officer has a duty to transmit this information to PCR, because PCR first must receive the information, that XYZ police station has arrested somebody and is in the custody of the person. So now they have done 2 things. They have imposed a duty on a police officer who has arrested a person to communicate to the police control room. And even at the police control room, they have designated one person for this task so that accountability could be fixed. So they have done this. Handcuffing is one of the contentious provision. there is a judgment of, again, the Supreme Court, which said handcuffing is illegal. We cannot treat human beings like animal. We cannot put them in chain, even if they are offenders. So that was prohibited. Only in extreme circumstances, handcuffing was permitted. Now, legislatively, they are saying that there are certain category of offenders, like repeat offenders, habitual offenders, people who commit the offenses against state. Even those people could be handcuffed. A lot could be said about this provision, whether it's a good provision, whether it violates existing judgments of the Supreme Court, etc. But suffice is to know that police now has the power to use handcuffs. Otherwise, if you have seen at the court premises or the police station, police will hold the hand of the accused like this, or they will just hold him like this so that the person does not run away. So there were ways of, but you couldn't use the chain, but now you could use the handcuffs. Now, they've also mentioned that in certain cases, you can't make automatic arrest, even the offense is cognizable. And they are saying these are the people which are infirm, which are above 60 years. And the offense which these infirm above 60 years have committed is less than 3 years. And in all these cases, you must take the prior permission of the DSP. Similarly, there was a provision in the CRPC about the arrest of a private person. However, now they are saying after a private person has made an arrest, the private person has a duty to transfer the custody of a police officer, or custody of the person arrested to a police officer within 6 hours. So they have introduced the timeline of 6 hours within which a private person must hand over the custody to the police. Then I've already mentioned organized crime, terrorism, heinous serious offenses. Section 43 provides handcuffs. Then arrest of women. Police must ensure that only a female police officer carries out the arrest. And only in the urgent circumstances, you could have a woman arrested by a male officer, but generally it's female. And now, medical practitioner, there was a right as well as a duty. That, say, for an example, if it's a offense which requires medical examination, right? So CRPC has a provision that you could do that medical examination. Police can ask for that medical examination. And in some cases, accused could be asked to undergo medical examination, could be asked to give medical report, could be asked to give hair sample, semen sample, so many things. Now, again, to make the procedure quick, they have said that these reports which are prepared by the medical doctors, they should be submitted, forwarded without delay. Now, as I mentioned, there's a lot of focus on the digitization, and it's not just part of the CRPC. You could see it across all the laws which have been amended or introduced by the present regime of the government, that they want everything to be digital. Digital is their biggest mantra. They want to just capitalize electronic communication. So they have made host of changes, provision in the host of changes now, wherein audio video means could be used. So for an example, issuance of process. Process means issuance of summons or issuance of warrant. Now summons or warrants could be electronic. Electronic means you could also send summons to a person through WhatsApp, email, etc. Either they are issued by the court or by the police, does not matter. It could be electronic. Section 2 defines what audio video electronic means is, and it also defines what does an electronic communication mean. This is not the class to discuss these definitions, but these terms have been defined. Then summons to witnesses and accused may be served electronically as per state government rule. Now, the rules to give these summons to the witnesses and accused will be decided as per the state government rules. This is not part of the law. Even the statements which are recorded by the investigating officer could be recorded by audio video means. Document like police report can be provided electronically. Search operation, search which is happening, or if you are seizing something out of that search, say for an example, police officer goes to some house or office and starts searching various documents, entire search must be videographed. Similarly, if you're conducting a seizure, if you're taking something in custody, some property in custody, which is called seizure, then you must also electronically record that. And even when you're doing search without warrant, you must do it with audio video means. Now, in many of these provisions, when the police is recording the statement of the accused through audio video means, when it is conducting search through audio video means, they are saying police officer can use his personal camera. Now, how practical it is for a police, or how long can a person keep using his personal mobile phone? Like, I have my mobile phone, I do not record outside world, but still my memory is full, and the speed of the mobile goes away. Second thing, in my mobile, there are so many apps I know, and all of you have these apps in your mobile phone which can access your photos and videos. Now, police officer is using his personal phone. Investigation is something, the data which you're collecting should be kept in some privacy, some confidentiality, so that privacy is not violated. And these apps could be used. They could get your data, and whatever police is collecting could just be circulated in the cyber world. So there are no privacy measures, to say so, in these things. Second thing, why a person, while performing a public function, doing investigation, should use his private devices to do this. Third, there should be some kind of cloud storage or somewhere. Say, for an example, after how many days can I record this video? How long can I keep a video? How can I transfer the video without violating the rules of electronic evidence? So all these things are not properly thought out, are going to create some challenge in the future. Parliamentary Standing Committee, which reviewed the bill on BNSS, also made a remark, expressed its concern over privacy, but legislature, in its wisdom, thought to still continue with these provisions. Then these are other provisions which talks about technology, digital evidence. Say, for an example, trial, inquiry, proceeding could be done electronically. Courts or police can summon electronic communication containing digital evidence. This is under a lot of scrutiny. You have a mobile phone, and police think that your mobile phone contains an important piece of information relevant to the case. Police officers could summon your mobile phone. Can you imagine a life living without your mobile phone, and you don't know for how many days, because now it has become an evidence for the police station. It has become part of the case. How do you get your mobile phone back? What are the rules to get it back? When can a police officer get your laptop, mobile phone, tab, or any digital device? So they can summon any electronic communication containing digital evidence. How does the police decide? Does this provision violate doctrine of self-incrimination mentioned under Article 20, Clause 3 of the Constitution? Because my mobile, anyone mobile may have many things which are personal to them. Now, can the police use this provision to actually harass people? So the idea of any criminal procedure, as I mentioned in my introduction, was to curtail the discretion of the police or to expand their discretion so that it's unchecked and it's unfettered and the rights of the people, citizens could be violated. Then accused can receive copy of statement, document. I was saying earlier, they have a right to receive police report. They can receive it electronically. Even the attendance of the accused, because this is not just a matter of convenience, it is also a matter of expenditure. For bringing every accused to the court from a prison is a lot of expense. Furthermore, sometimes it could be convenient, many other issues. So now they are saying it was also there in the CRPC, but it was by virtue of the interpretation of the judgment of Supreme Court that they said attendance in person could also mean attendance to audio video. Now they have made it part of the law. There is again a lot of thrust in the criminal procedure in the Bharatiya Nagarik Suraksha Sanhita on the forensic expert, and they have made it mandatory that forensic experts must visit the crime scene, every offense punishable with more than 7 years. Now, the law, this provision with respect to technology, whatever forensic expert is doing must be videographed. So if they're collecting some samples, if they are demarcating some area, whatever they are doing should again be videographed. And then there was this provision of cheating. There's this big problem, online frauds, etc., which court have a jurisdiction with respect to a cheating which has been committed online? You don't know. So now they are saying with respect to cheating which has been done by electronic means, any court can entertain that matter, and there are no factors whether X court can exercise jurisdiction over such matter and Y cannot. Any court before which matter has been pressed could entertain such matters of cheating by electronic means. Then there is this issue of custody. Now, there is this landmark judgment of the Supreme Court of India came 2-3 years back called Satendra Kumar Until versus Central Bureau of Investigation, CBI. And this judgment recommended that when you file a charge sheet, and when you're filing charge sheet, by that time you didn't arrested the accused. So now you also don't require to arrest the accused. You just take the security for appearance, you make him execute a bond and ask him to appear. You don't have to compulsorily arrest the person when the charge sheet is filed. So magistrate, again, obligation has been imposed upon the magistrate that magistrate, the person to whom this police report has been submitted, cannot also refuse the why you haven't taken the accused into custody, we can't accept police report. No, that's not what the magistrate could say. Magistrate so fine, you have taken the bond, security for appearance, that's fine for me, and I'll accept your police report. Police report is called by many names like charge sheet, challan, closure report, whatever nomenclature you are aware of. Then this most contentious provision, something which has attracted a lot of commentaries, how many days police can get a custody. Under CRPC, police could get a custody of 15 days. Here also it is 15 days, but it could be extended. There was a maximum cap of 15 days in CRPC, but that maximum cap is now extendable. Second thing, there was a provision of judicial custody for 60 days or 90 days as the case may be, depending upon the seriousness of the offense. Now, earlier, police custody could happen before judicial custody only. So there'll be first police custody. If there is no police custody, then judicial custody. Now they are saying police custody can also be taken in a staggered manner. So I have a cap of 15 days. And say for an example, I have the 40 days period. Then within these 40 days, I can bifurcate my 15 days. That within the first 10 days of 40 days, I want it for 3 days. Within the next 10 days of the 40 days, I want it for 2 days. Within the next 10 days of the 40 days, I need another 7 days. I can ask for the custody in a staggered manner. There are apprehensions that this could result into more custodial torture. This could result into police exerting a lot of pressure on the people accused of crime in order to extract confession from them. Only the time will say whether the custody in a staggered manner is a good provision, welcome provision or not. Then, as I mentioned, another important stakeholder in a criminal justice system, which was not always there, but there since a decade or so, is the victim. Otherwise, the role of the victim was very limited to be a witness of the crime. Because even if you know, victim cannot have his own lawyer representing him in the case, it is the public prosecutor. So state espouse your claim. State will handle the entire case. State आपको बोलता है, you go and sit at your home, we will take care. Now they are saying, even if this is true, victim should have some role. Okay. Now, first, they have said victim must be informed about the status of investigation within 90 days. You can't keep victim in dark. Second, the copy of police report, what investigation police has done, must be supplied to the victim. If the prosecutor is choosing to withdraw the case, then this withdrawal must be done only after listening to the victim, after hearing the witness. They are also saying that the state government must establish a scheme to protect the witnesses. So people could come independently, give testimony, especially in very serious offenses wherein witnesses could have danger to their life and liberty, could have danger to their property. There should be some safeguards created by the government so that there's a witness protection scheme after which their identity could be changed. They could lead a new life. They could be given a new home new occupation, everything, right? So his old identity will just fade away somewhere, and a new person in the eyes of law will be created. So these are some of the methods for witness protection, and now we are saying even state government should bring it. And now they also have the discretion over state government, victim compensation scheme like Nirbhaya scheme, one-stop centers, Manodhairya scheme. So there are many such schemes, Ujjwala scheme, all these schemes, state government has a discretion. How can you help victims of the crime with these schemes? Another important feature of our criminal procedure is in absentia trial. Now, it is a very important right in a constitutional state, in a rule of law state, that any evidence which is taken in criminal law is taken in the presence of an accused. So trial must be conducted in the presence of accused so that accused can see for himself that all the safeguards, etc., are being adhered. He know what case he has to contest, how he has to save himself from the crime. But now we are saying that there are few people who do not deserve this treatment, and they are saying even in the absence of these people, trial could be conducted. So this says this provision allows for inquiry, trial, and judgment against proclaimed offender. There is a provision of proclaimed offender under Section 84 of the CRPC. I think the same is also the section number in the BNSS, Section 84. There is a procedure to declare a person as a proclaimed offender, wherein a notice is given in a newspaper that we are declaring this person as a bhagoda, as a proclaimed offender. Now, with respect to this proclaimed offender, we are saying in certain kind of cases, because he's avoiding the trial, he's evading the trial, we would say that this person has waived his right to be present at the trial. Ki tum bhage kyun? Agar tum bhage, you have waived your right. Now you can't claim that you should have been given the opportunity to be present in that trial. So we are taking away that right from such people. Second thing, court can proceed with the trial and pass judgment as if the offender was present. So whether he is present or not present does not matter. So it is going to affect if we start the cases in case of Vijay Mallya, Nirav Modi, etc., who all are proclaimed offenders, and we could conduct the trial and we could pass a sentence. The only problem would be who to punish after conducting trial. But the best part is if there were many people and of them, some of them are absconded, then this provision also says that you can conduct the trial of all of them together, and those who were not there could be sentenced to jail when they are caught, and the remaining people who were present at the trial could be convicted and sentenced at that time. This proclaimed offender cannot appeal against the decision which has been given in this in absentia trial. He can only appeal after he comes in person. No appeal against conviction after 3 years from the date of judgment. So again, there's a limitation period on appeal. You can file appeal only if you come, but you should come within 3 years. So the entire idea, the person has disappeared. So the law is designed in such a way that you are forcing person to come. And it is also designed to prosecute offenders who have fled Indian jurisdiction, as I mentioned. Now, what happens? We are saying from 1st July 2024, this BNSS applies. What happens to CRPC? What are the cases which will be dealt by CRPC and what are the cases which will be dealt by BNSS? So this is the last section of the BNSS which says appeals, application, trial, inquiry, and investigation pending before BNSS comes into force will be dealt with under CRPC. Means everything prior to 1st July will be dealt as per CRPC and not under BNSS. Such pending cases will be continued as if BNS had not come into force. Okay. The only exception is for the inquiries under Chapter 14 of the old code, and they are saying at the time of BNSS commencement will be handled according to the inquiry which were handled prior to that will be according to the provisions of the BNSS. So the idea is BNSS does not have a retrospective effect. Generally speaking, procedural law could have a retrospective effect, but just simply to avoid confusion, they are saying that appeal, application, trial, inquiry, investigation, after everything new would be as per BNSS after 1st July, and older things, these appeal, trial, inquiry, investigation will be as per CRPC. This is what this is saying. And thank you so much. This was my presentation on the changes which have been introduced in the BNSS. If you have any questions, you can ask me for the next 5-10 minutes.
Okay, sir, give us few minutes. I'm just asking few questions.
इसमें हमको participants क्यों नहीं दिख रहे हैं? Means how they have joined?
Sir, I need to check it with the IT team.
क्योंकि
Will
जनरली मतलब अगर हम उसमें वेबिनार फॉर्मेट में भी करते हैं तो वो दिखते हैं ना?
I'll check with the IT team, sir.
Okay.
Starting the question, sir, what is the role of forensic expert and who can be the forensic experts?
Who could be forensic expert depends upon which kind of forensic science are you talking about. Point number one. The definition of expert is not dealt under Nagarik Suraksha Sanhita. It is dealt under Bharatiya Sakshya Sanhita. And expert could be any person who has the specialized knowledge about the subject. Say, for an example, with respect to bombs, there are different forensic experts. With respect to DNA, there are different forensic experts. With respect to chemical evidence, there are different forensic experts. So it depends upon which subject you are talking about. And within that subject, there are different specializations. Now, we do not have a lot of forensic experts in our country who could understand crime. That's why Indian government have set up National Forensic Science University. And they haven't implemented this provision of forensic expert immediately also because they recognize first we need to build adequate number of facilities which can test these reports. Also, we need adequate number of specialized people who can be trained. And that's why you would see there are many forensic universities which have been established in a year or two, and there are some more which are being created so that the experts in this field, human resources in this field, can be created. There could also be forensic experts, say for an example, to match the digital signature, right? So the term is very broad term. Forensic means scientific. It means objective. So any person who applies scientific method, who apply objective method to identify the truth, it is called as forensic science.
So the next question is there any limitation? What are the crimes that can be punished in trial in absentia? Are all the crime can all the crime be punished? Like while
No, those cases, only the cases of proclaimed offenders can be tried in absentia. Not all the cases can be tried by way of in absentia trial. The person should be declared as a proclaimed offender. That's the first thing. Second thing, the offense should be punishable with more than 7 years of punishment. These are the two things with respect to in absentia trial.
sir, with respect to the changes in the provision related to judicial custody and police custody, will it impact the right of bail? Can it impact right of bail of a person? Because sir, earlier it used to be first of all we have police custody, then judicial custody. Now police custody can like go after that also. So
No. So this does not really affect the bail. See, there are three things. When a person is produced before a magistrate, magistrate has three choices. First, to order police custody. Second, to order judicial custody. Third, to order bail. If you have been given bail, there is neither a question of police custody nor a question of judicial custody. The question of staggered police custody only comes when a person has been refused bail and the person is lodged in judicial custody. There is a maximum timeline for which they have mentioned for the judicial custody, 60 days or the 90 days as the case may be. So If it is a case pertaining to 60 days, they are saying within first 40 days, you could have your 15 days staggered. But in any case, the person is already in custody. And that is why it does not affect the right of bail.
The next question is, why changing nomenclature? Do you think purpose or intention of the lawmaker is being served besides to get rid of colonial mindset?
I didn't get your question. By the change of nomenclature,
Do you think purpose or intention of lawmaker is being served beside to get rid of colonial mindset, sir?
see, colonial mindset does not change just by changing the name of law. Point number one. As I mentioned, institutions like police, they are themselves colonial, right? That we should police our co-citizens. We should use force is a colonial idea. So anything which is based on the idea of force, which is based on the idea of suppression, is a colonial idea. So that doesn't change with the name of law. The intent is good, as I mentioned. The focus of the government is ease of living, and the focus of the government is also that the law should be citizen centric and victim friendly. To that extent, the law also reflects these changes. Moreover, the law is intended to be modernized by use of electronic means, though there are concerns related to cyber security and privacy. But I think the intent is fine, that the law in the 21st century should be modernized and people shouldn't be made to be physically present in the court.
Yes, sir. You said accused right to vote is taken away. But what about right to contest in election? We have seen recently in Jammu and Kashmir that a convict person who was found disturbing the integrity of India was allowed to stand in election. Do you think this should be addressed in the new laws?
No, convicted person cannot contest election. The person might not have been convicted. His case might have been pending before the courts. I don't know the facts of the case, but it's a clear judgment of our Indian courts, wherein a convicted person, the person could have been in custody, which is a different thing, could have been under trial also, but might not have been convicted by the court. Being in detention and being convicted are two different things.
Sir, whether BNSS covers artificial intelligence crimes?
That is the subject matter of Information Technology Act. BNSS is a procedural law. Crime is a matter of substantive law. So either it will be under your Bharatiya Nagarik Sanhita or Information Technology Act. That's not the concern of BNSS.
The next question is, what do you mean by false imprisonment, which is also a concept of torts?
It is a concept of tort only. In the corresponding provision is in the Bharatiya Nagarik Sanhita, which is the concept of wrongful confinement. Means it is again a criminal offense. It has nothing to do with criminal procedure. It might have something to do with the criminal procedure. Say a wrongful custody of a person has been taken. That could be called as false imprisonment or an offense of wrongful confinement. If a person is illegally arrested, so illegal arrest, custody in a person, it can be called as a wrongful confinement or false imprisonment, as you are mentioning.
Sir, please also explain the concept of arrest by a private person.
See, arrest is not just the mandate of a police officer. Okay? Magistrate can arrest, private person can arrest, and a police officer can arrest. There's already a provision in the BNSS that administration of criminal justice system is not just the role of the police officers or the courts. Citizens must also aid police and your institutions like court. It is from that perspective, in certain cases, even private persons have been given the right to arrest. Now, in your presence, an offense has been committed. Should you wait for the police to come and arrest the person? You can arrest the person. Similarly, sometimes, and I don't actually anticipate, say for an example, private person as arresting people. What if the other person is a dangerous person? I guess that there are cases, say for an example, which are investigated by private investigators. People hire detectives, etc. So detectives could also arrest a person. You hire it, you yourself is not arresting. Detective could arrest a person, and then it is the duty of the detective under this law to hand over the arrested person within 6 hours to the police. So that's the law is about. That any private person, but primarily the people who would be arresting would be detectives or in the work of law enforcement, though not labeled as a police officers or magistrates. That's
Okay,
the
sir.
idea of private person.
So, sir, the questions comes to an end.
No problem.
So, sir, we are thankful to you that you took time from your busy schedule and gave such an insightful and knowledgeable session. So, for the members, the next Triple E webinar is to be conducted after the National Convention on 13th November 2024. Thank you all.
Thank you.
One second, Minalji is communicating to you. IT support, Minalji is communicating with you. Wait for a second, please.